Getting a traffic ticket is a drag. It's also expensive and may harm your insurance. And paying for a ticket is only adding salt to a very deep wound. So, why on earth would you pay the ticket if you have other options? Don't pay the ticket, but instead watch this video as I take you through the entire traffic ticket process, including what you should do when a police officer stops you, your options, how to defend and fight your traffic ticket, how to present your case in court, and the defenses available to you. Welcome. My name is David Jolly. This video will take you through the entire traffic ticket process. I've also created a quick guide on how to defend your traffic ticket that is available for free by simply clicking the link at the end of this video. Before we jump into business though, just a little bit about me and my experience with traffic tickets, contested hearings, and the entire court process. My first real legal job was back in the 1990s, and it was as a prosecuting attorney. For 3.5 years, I probably prosecuted over 10,000 tickets, and almost all of those who represented themselves lost. The reasons were usually obvious. That is, they argued the wrong things. Following my days as a prosecutor, I appeared on thousands of traffic tickets for clients of my own. In 2011, I wrote the Traffic Ticket Handbook, and during the past several years, I have also appeared as a judge pro tem in contested hearings. Let's start at the very beginning. Being stopped by a police officer for a traffic ticket is no fun. In fact, it's very aggravating. Most of us have been stopped for a speeding or other minor traffic violation at least on one occasion. If you have been stopped, you may have felt nervous, anxious, violated, embarrassed, and sometimes even angry. But if you have been stopped for a ticket, my first piece of advice is breathe. Take a deep breath and put everything in perspective. Here's what you should do after being stopped by a police officer. Have your driver's license, insurance, and registration ready if you can easily find them. Do not make any sudden or furtive movements. This may make the officer nervous, and you don't want that, particularly in today's world. Be polite. You may not want to be, but do your best. There's always a chance the officer may give you a warning if the alleged violation isn't serious. If the officer likes you, you may in fact benefit. If you still get the ticket, the officer may make comments in the ticket that you were polite, and this may later help you in court. Do not lie. You won't get any breaks, and the situation may even get worse. Don't talk too much. Yes, answer the questions you must, such as your name, but do not volunteer additional information. And finally, if you receive a ticket, do not discard the ticket. It's okay to be angry, but save that ticket so when you're calm, you can prepare to defend yourself properly. Receiving a traffic ticket is awful, right? We don't like them. They're expensive and they can harm your insurance. But don't bury your head in the sand after the officer gives you a traffic ticket with a smile. If you need a few hours to calm down, take those few hours. When you're ready, here is what you should do. Read the ticket to determine how long you have to respond. In my state, you have 15 days to respond if the ticket was received in person and 18 days if the ticket was served by mail. Confirm where you should send the ticket. The specific court is very important. The ticket could be municipal court, a state court, a tribal court, or a federal court. Where you should send the ticket should be printed directly on the face of the ticket. Decide what you should do. Do you want to contest the ticket, mitigate the ticket, choose an option such as deferred finding or driver improvement, or just pay the ticket? Don't just pay the ticket. That's the wrong choice. Make a copy of the ticket. Mail or deliver in person the ticket to the proper location. Wait until you receive a summons from the court confirming your court date. Research how to beat your ticket or call an attorney if you are considering representation. Once you have received that dreaded traffic ticket, be sure you read it front and back. There may be options right on the ticket itself, and the ticket will request that you choose one of those options. One option you should immediately ignore is paying the ticket in full. No, do not do that. One option you should consider, however, is a contested hearing. This is when you defend your case in court and the judge decides whether you committed the infraction or if the ticket should be dismissed. Another option is a mitigation hearing. This option is when you admit that the violation has occurred and ask for the fine to be reduced. Other options may include a deferred finding, which will dismiss your ticket in exchange for a fee. Another option is called an SOC, or Stipulated Order of Continuance. They're called different things in different courts, but essentially this is an agreement that the case will be dismissed after a period of time if you pay the fee and stay out of trouble. Yet another option your court may offer is a dismissal of the ticket in exchange for the completion of a defensive driving class. This option is often referred to as driver improvement. Finally, you do have the ability to negotiate with a prosecuting attorney if one is present and is willing to negotiate. Such negotiation may be fruitful if it reduces the moving violation to a non-moving violation and does not count for points in a point-based state. If your ticket only offers a contested or mitigation hearing, always choose the contested hearing, as you have other options such as the deferred finding or dismissal after a defensive driving class once you are in court. If you believe you did not commit the violation, then you should check the box entitled Contested Hearing directly on the ticket and then properly submit it to the correct court. A contested hearing is similar to a very informal trial with civil rules of evidence. Your case is heard before a judge or commissioner who will determine if you have committed the infraction or if the infraction should be dismissed. If there is no officer subpoenaed, the evidence will consist of either the judge or prosecuting attorney reading the provided police report into the record. If a police officer is present or if an expert, such as a speed measuring device expert, is appearing, they will provide testimony. If testimony is provided, the prosecuting attorney will ask questions of their witness, and the defendant, you, will then have an opportunity to cross-examine the prosecutor's witnesses. Once the state has presented their case, the defendant has an opportunity to testify under oath. This is your opportunity to present your case. Remember, if there is a prosecutor present, he or she can then ask you questions, and so too can the judge. Once the parties have presented their case, the judge will then make a decision. As a reminder, prepare a solid defense, and it's important to present it in a clear and persuasive manner. Good luck. A mitigation hearing is where you admit that you did commit the violation but wish to explain the circumstances of the infraction and have the court reduce the fine. Most courts will permit you to change your mind in court and switch from a contested hearing to a mitigation hearing if you so choose. The judge, depending on the explanation and your traffic ticket record, may adjust and reduce the penalty, but the judge will not dismiss your ticket. So why on earth would you choose the mitigation option? Well, there are some instances when choosing to mitigate does make some sense. For example, non-moving violations in most states do not affect your insurance or driving record and may not be worth fighting. Such tickets may include parking tickets, equipment violations, and so forth. Another reason to mitigate is some courts will permit you to mitigate your ticket in writing, therefore avoiding having to appear in court and taking time off of work. But there is a word of caution with mitigation hearings. Be careful, as some states have a point system and some non-moving violations may count for points. And this is exactly why researching before court is so important. Several states offer programs that will dismiss your traffic ticket if you have a clean driving record. Check your state to see if such a program is offered, but in my state, Washington, the program is called a deferred finding. Importantly, a deferred finding allows for the dismissal of the infraction. It's important to note that not all cases are eligible for a deferred finding and dismissal. But if eligible, the infraction will be dismissed at the end of the time period imposed by the judge if the defendant does not commit any traffic violations and pays the costs imposed to monitor your case by the due date. A person is only allowed one deferral in a 7-year period. A finding of committed will be entered with the DOL or DMV if you receive a new violation during the deferral period or if you fail to pay the court costs. Those drivers not eligible include a holder of a commercial driver's license who was operating a commercial vehicle at the time of the violation and a driver who has received a negligent driving second-degree ticket involving a vulnerable user, including a pedestrian, bicyclist, or motorcyclist. Remember, you can only use this option once every 7 years in Washington state. Another option in court when fighting your traffic ticket is called an SOC, or a stipulated order of continuance. Different courts and states may use different names, but essentially, this is an agreement or contract that your ticket will be dismissed after a period of time if you pay a fee and stay out of trouble. The period of time could be as short as 6 months long or as long as 2 years, but in my experience, the most often used time period is 1 year. At the end of the period of time, the matter is reviewed administratively and then dismissed. But be careful, as a new traffic ticket during this period of time will result in a finding of committed, and the old ticket will now be on your record. In states that have a driver license point system, a driver improvement program may be worthy of consideration. In some instances, the program may even be mandatory. The program involves the completion of a defensive driving course, often 4 to 6 hours in length, that is designed to teach drivers about safe driving attitudes and behaviors. Driver improvement courses may be court-ordered, required for driver license reinstatement, or at the option of the driver for certain benefits. Such benefits of the program may include no points on your driving record because points are not assessed. They may reduce the total fine amount and even prevent auto insurance from increasing. If none of the options mentioned in this video are appealing or even available to you, then you may have one last option: negotiating with the prosecuting attorney. When I was a prosecutor, I would occasionally offer to reduce moving violations, such as speeding tickets, to non-moving violations. The benefits to the defendants was a guarantee, at least in my state, way to keep the moving violation off of their record and their insurance not to be affected. The benefit for my office, the prosecutor's office, was that there was money coming into the city's coffers. The benefit to me at the time was that it saved me some time fighting the ticket or tickets, and I left the court earlier. A prosecuting attorney may offer you such a reduction in court. Now, it doesn't always happen, but occasionally it does, so you should be open to it. But before you do, be sure you do your research about what non-moving violations will not harm your insurance if you're in a points state. So be cautious, as non-moving violations may still impact you in some way. The defense that you did not commit a traffic ticket based on your own testimony that it didn't happen is traditionally weak. During my time as a prosecutor, I heard thousands of defendants argue that they didn't do it, that they didn't speed, that they did signal, that they did come to a complete stop, and so forth. The minute I heard this defense, I typically knew the argument would fail, and I would sit back and listen, then attack this approach during my oral argument. Very few defendants prevail using this approach. That being said, these arguments can win if you approach them in the correct manner. You need to prepare, and the argument will be much stronger if the officer's notes lack detail. For instance, if you're arguing that you were not speeding and the officer cited you for speeding based on pacing your vehicle, the lack of detail in the officer's notes can be defeated by you supplying testimony that attacks this very lack of detail. Instead of speaking in generalities or hypotheticals, let's look at some examples where a factual defense may work. The factual defense is the most commonly used defense in traffic court by non-lawyers. The first example, which is from a former case of mine, is when the law enforcement officer cited a person for failing to stop at a stop sign. The problem is that there was no stop sign at the intersection. In this case, take photos of the location and be sure the street names are visible. Take this photo to court and argue your case. The second example is again a mistake by the officer. This person was cited for speeding 35 miles per hour in a 25 mile per hour zone. The problem is that it was a 25 mile per hour zone. Be sure you go back, take photos and a video if necessary, and take this evidence to court. Again, if you wish to use this factual defense, you must prepare ahead of time. Attack the officer's lack of detail and give testimony that adds information or facts where the officer lacked such descriptions. Simply saying something did not happen is rarely enough to prevail in a court of law. Focusing on details and mistakes is how you find fault in the case and how you win arguments. It's time to focus on finding technical issues that dismiss cases. Individual officers issue hundreds or even thousands of tickets a year, and guess what? They make mistakes. They cut and paste facts, they get distracted, or they're just sloppy. They are, after all, human. But whatever the reason, mistakes exist, and it's your job to find those mistakes. The first thing you need to do is get the police report. To get this, you must properly request the report, we call it discovery, from the proper source. The source is usually the prosecuting attorney, but if you're not certain, phone the court clerk and ask where you can get discovery, or go to the court website and find out where you can correctly request discovery. But be careful, as you must request discovery timely, meaning you must do so within a certain number of days prior to your court date. Such technical defenses that may result in the dismissal of your case include the incorrect name of the driver, wrong license plate number of the vehicle involved in the infraction, wrong vehicle description, wrong street or highway where the infraction occurred, the officer failing to sign the ticket, wrong gender of the driver, wrong traffic code with which you were cited for violating. Technical issues are a great way to fight a traffic ticket. Be sure you thoroughly go through the ticket and the discovery and locate errors, omissions, and inconsistencies. Admittedly, some technical issues are more powerful and successful than others. Some of the issues I mentioned will work in some courts and others not as much, but they're all fair game in the war of contested hearings. If you're fighting your ticket, I highly recommend looking carefully into the procedure defense. Very simply, if the prosecuting authority fails to follow certain procedure that's required by court rule, your case must be dismissed. Before you can argue any infraction procedure, though, you must first understand it. And admittedly, civil procedure is about the dullest of all legal topics, and that is really saying something. The first thing I do recommend is looking up the court rules. And yes, that too is very boring. Most courts have similar procedure rules, but they're not always the same. So, search your court on Google or Bing or Yahoo if you use that, and locate the contested hearing rules for your specific court. Another important and related search should be for your state's infraction rules. Each state has different names, but in my state, these are referred to as the infraction rules for courts of limited liability, also known as the IRLJ. Both the court rules and the state infraction rules have information regarding time deadlines for requesting discovery, providing discovery to you, and the filing requirements of the infraction with the court. When the court uses the term discovery, they're actually referring to the police report and court-related documents that will be used against you in court. Requesting the discovery or police report is a good place to start with every single case. The discovery should contain information about, if it's speeding, like the radar or laser device if used, including a speed measuring device affidavit and the officer's notes, often called the narrative. If you request the discovery, the prosecution must deliver the discovery within a certain amount of time. If you request discovery and the prosecution fails to provide the documents, then this information cannot be used against you, that is the narrative and the police report, and it is probable that a dismissal will be granted by the court. The following information is important to know prior to using this defense. Prepare a thorough document requesting all pertinent information relating to the traffic ticket or request for discovery. Send the request for discovery to the correct parties, usually the prosecuting attorney and the court. Confirm the deadline to deliver this document. Confirm how the documents should be delivered, directly filed, emailed, faxed, mailed, or in person. And prepare a declaration of service. Let's now look at some examples of the procedure defense. Procedural defenses are my favorite defenses, and usually there is little discretion left for the judge. And believe me, we would prefer not to give the judge discretion. The first example is the request for discovery defense. Essentially, it works like this. If you request the discovery, which is essentially the police report, and you do so timely, the prosecuting attorney must provide you with the report. If they fail to provide you with this report or don't do it timely, you win. What you must do is provide evidence to the court that you mailed or faxed or emailed such a request. You can do this by confirming it was received or by signing a declaration of service. An example of a declaration of service is on page 31 of the Traffic Ticket Defense book, a free guide linked below. Once you have presented proof that you have requested a copy of discovery and that you never received it, you can move to have the evidence suppressed and the ticket dismissed. To really impress the judge, be sure you quote your state's evidence rule. The second example is the filing of notice. There is a deadline that the state or city must file this ticket by. Find the evidence rule. In Washington, for example, it is a total of 5 business days. If you're unsure when it was filed in court, ask the court clerk or ask the judge when your case is called when the ticket was filed. If the notice was filed longer than 5 business days, for example, after you were cited, ask the judge to dismiss the case. It's a lot of work to request the proper documentation, but if the prosecutor does not comply, then you should be the recipient of a dismissal of your ticket. One of the greatest gifts to an attorney defending traffic tickets is the MUTCD defense. But what is the MUTCD defense? MUTCD stands for the Manual on Uniform Traffic Control Devices and is a document issued by the Federal Highway Administration of the United States Department of Transportation. This manual standardizes traffic signs, road surface markings, and signals and the manner in which they are designed, installed, and used. Such specifications include the shapes, colors, and fonts used in road markings and signs. In the U.S., all traffic control devices must generally conform to these prescribed standards. While some state agencies have developed their own set of standards, including their own MUTCDs, these must substantially conform to the federal MUTCD. This rhetoric is actually important because the MUTCD can prove to be a friend to you in court. But you must be very prepared, as it may be you who will have to not only argue the defense, but also educate the prosecutor, police officer, and even the judge. The MUTCD defense can be used for most every moving violation defense that involves posted directions and controlled intersections. Such moving violations include general speeding, school and construction zone speeding tickets, failing to yield or stop, and so on. Let me give you a few examples of how the MUTCD defense can be used. The MUTCD defense contains many little gems, but of course, the dilemma is how do you find these potential legal issues in a book that is over 800 pages long? Well, first, you locate the book, and you can easily do that by clicking on the link in the description below. You can then download the manual for free. Once you have done this, click on the search button and type in your search. Once you have located the area of the book pertaining to your legal issue, carefully read the pertinent parts of this guide. You'll quickly find numerous potential defenses, but let's look at a few quick examples. The first example involves an actual stop sign near Jackson, Wyoming. The police report reads, on July 15, 2020, near the Amangani Hotel in Jackson, Wyoming, I observed a BMW X7 fail to stop at a clearly marked stop sign. All right, when we compare this example with the MUTCD font, it clearly is not the same. We can argue, I guess, if the meaning is the same, similar, or different, but the bottom line is it's clearly not what the MUTCD considers to be a standardized message. This is still an awesome sign, though. The facts in the next example read, the reported vehicle failed to stop at a clearly designated stop sign. The MUTCD clarifies the height of the stop sign in section 2A.18 regarding the mounting height. The MUTCD states in part, the minimum height measured vertically from the bottom of the sign to the elevation of the near edge of the pavement of signs installed at the side of the road in rural areas shall be 5 feet, and of signs installed at the side of the road in business, commercial, or residential areas where parking or pedestrian movements are likely to occur, or where the view of the sign might be obstructed, shall be 7 feet. Well, clearly this sign is neither, and it is too short. The third example of the MUTCD defense, also using a stop sign as an example, is a common problem in urban areas. Section 2B.01, Application of Regulatory Signs Standard, states regulatory signs shall be designed and installed to provide adequate visibility and legibility in order to obtain compliance. Signs that are obscured by vegetation and not adequately visible are not in compliance with the MUTCD. Now, there may be better examples, but if you were cited with a traffic sign related ticket, whether that be a stop sign, yield sign, speed limit sign, and so forth, and the sign was obscured by, for example, vegetation, be sure you take a good photograph before the vegetation is removed and bring the photo with you to court with this MUTCD reference. The MUTCD defense is a great way to dismiss a ticket in court. It's often underutilized by those representing themselves and even by attorneys. It does take a great deal of work, though, but if your goal is a dismissal, it may well be worth the effort. Legal arguments can prevail in court and are a great way to get your traffic ticket dismissed. finding a flaw in the evidence when compared to the statutory citation, or finding an obscure legal case on point can deliver the goods in a contested hearing. But you must start by thinking, unfortunately, like a lawyer. If you haven't already, you must request the discovery or police report in your case. It's important to read what the officer has written in order to determine your specific legal defense. Once you have done this, you should then find the statute for which you were cited. Every state has their own traffic codes and, of course, their own statutes. Cities also have their own municipal traffic code, so be sure you reference the right law. This code should appear on the face of your ticket. You should also find the specific section that you allegedly violated. Once you have read the statute, you must then reference this code to the facts or evidence submitted by the police officer. Let's look at some examples. The legal defense is the most complicated. The first example is where a driver was citing for not signaling. However, the officer stated he observed the driver fail to signal while turning. A quick look at the statute reveals that the signal must be done before turning. This case must be dismissed. The second example is where a person was cited for not having his lights on right after sunset. However, the statute states the lights need not be on until 30 minutes after sunset, unless it was dark, say, for another reason. But this was not indicated in the facts. Be sure you validate the sunset times and bring proof of these times with the statute to court. The final example of a legal argument is the most complicated. Case law. In this example, the officer fails to provide important foundational evidence regarding the details and reliability of the radar unit used. Much more information is needed to ensure its reliability, calibration, and the officer's certification. And this is easily achieved with something called a speed measuring device affidavit, which was not used in this particular case. If you really want to show off and impress the judge, cite a case that requires the state to provide more information, such as the Washington State case in this example. If the statutory argument fails, you still might be able to find an interpretation of your offense that can still assist. I'm referring to, of course, case law. Case law is law that is based on judicial decisions rather than law based on constitutions, statutes, or regulations. Case law concerns unique disputes resolved by courts using the concrete set of facts of a case. Most lawyers use a database to locate cases that may apply, and very experienced attorneys probably have a book of thousands of cases that can be used for certain legal issues. But this probably isn't you. What you can do on your own is research on the internet to see if anything close, maybe, hopefully, pops up. You may get fortunate, as some attorneys do provide applicable cases on their websites, and there are some judicial bench books that are available online that give a list of applicable cases for contested hearings. Remember, you should cite the right cases that have authority. For example, a California case may not have any authority for a New York traffic ticket. If you decide to fight your ticket using case law and statutory interpretation, you're now thinking like a lawyer. Be sure you understand the law and be certain you know how to apply it, as the judge and prosecutor most certainly will. That being said, having a case dismissed because an officer misapplied a traffic code is about the most fulfilling way to beat a ticket. When you're fighting your traffic ticket, the court will be considering if the state or city has met their burden. In civil hearings, the burden is called by a preponderance of the evidence. Black's Law Dictionary describes a preponderance of the evidence as standard of proof in civil cases is evidence which is of greater weight or more convincing than the evidence which is offered in opposition to it. So that's really helpful, isn't it? But let's be a little bit more practical. In the United States, where a traffic ticket is a civil infraction and the standard of proof is by a preponderance of the evidence. This means essentially that if the city or state finds that it is more likely than not that you committed the offense, you lose. In these types of cases, it's far easier for the state and the prosecuting attorney to prove their case against you, as the burden on them is far less than in a similar criminal setting. Therefore, absent a procedural defense, you must have more evidence that you did not commit the offense than the prosecutor has that you did. In the 1990s, tennis star Andre Agassi advertised for Canon cameras and professed that image is everything. Well, your image or the impression you give may not be everything on the court or in the court, but it does have its place, and it is important. Your image and the impression it gives is very important in court. Whether you are in court for a criminal case or an infraction, follow protocol and don't give the judge a reason to dislike you. Some rules usually include conservative clothing, no hats unless they are permitted for a religious reason, no food or drink. So, what should you wear? Well, you don't need to wear your Sunday best, but do wear nice, clean clothing. Avoid clothing that has graphics with messages. And remember, conservative, like it or not, conservative is usually a very smart choice. When you're in front of the judge, be polite, courteous, prepared, and do not interrupt the judge. When representing yourself for an infraction, the judge will expect that you know what you're doing and that you understand the basic court rules and rules of evidence. Judges are impressed by those who are prepared, present well, and articulate their case. When it comes to contested hearings, a good impression may give you and your case more credibility and may ultimately persuade a judge to rule in your favor. Fighting your traffic ticket can be a great deal of work, but if you truly believe that you did not commit the infraction or a traffic violation will cause significant impact to your driver license or insurance, you have nothing to lose. But be sure you start your defense right away. And a good place to start is by clicking on the link in the description below for your free guide on how to beat your traffic ticket. And for more videos on how to win in court, dismiss that traffic ticket, please subscribe to this channel.